Our concern is primarily about these small wireless facilities because they go closer to residences, and there are people who have health issues related to exposure to the 5G microwaves. So I know that health is not directly related to most of this ordinance, but there's some way that it can be included. If we're concerned about it, can we make that there has to be some consideration for the health of the people surrounding where these facilities are going to be located?
Yes, absolutely. So you always will have a consideration for people's health, and if any facilities are operating outside of the prescribed standards, then you can set them to be an emergency such that you can turn off the facility and or revoke and remove the facility, revoke the permit and remove the facility. The issue is that under the federal law, no local municipality can set regulations related to the emission standards. Only the FCC can set the emission standards. The subsection is 47 U.S.C. 332 C7B4, that no local, state, or government can regulate based on the environmental effects of radio frequency emissions to the extent that the facilities comply with the FCC regulations.
Can I ask a question?
Has set regulations, and the municipalities can enforce compliance with the FCC's regulations, but they cannot promulgate new regulations.
Okay.
Hold 1 second, we have a question.
With regard to enforcing FCC regulations, Mr. Campanelli mentioned that sometimes the companies state a different amount of radiation that's allowable than what is really allowable for ordinary citizens. There are FCC, as far as Mr. Campanelli said, has two levels of allowable regulation. One is set for workers, I guess, who are allowed to be exposed to more because they're only working a short time. The other one's a lower value. And what Mr. Campanelli was saying is that we need to maybe have in our ordinance some kind of statement that we are going to have the authority to test ourselves the level of radiation at any time without notice. And that way they are given notice that they need to make sure they provide the correct information with regard to radiation. Could we do that in the ordinance?
Yes, you can do that in the ordinance. So that's kind of one of the other things that is, we go from 80, 90% to 100% that we would include in an ordinance, is that there are standards set by the FCC, and you can require both that the wireless carrier or operator submit. We do biannual every 2 years that they submit automatic reports, and anytime there's maintenance or they do an upgrade, that they also do testing, and that the municipality can request the carrier to do testing at any time, and also the municipality can test at any time.
Great. That was a major, I think, point that some residents made, I think, with regard to that.
Anybody have follow-up questions about that?
Sorry, Dennis, I didn't hear you.
Because I think that would go a long way to addressing something.
Yeah. That's all the questions I have right now. So.
There's no meter that they continuously, because they could be out of compliance one day and in compliance the other.
Yeah, the question is, can most municipalities actually handle the testing?
Right.
What kind of technology is required locally to confirm that everything is copacetic or everything is up to standards?
Yeah. So and you also do need somebody to read these reports. If you've seen these reports, it's not like reading a law brief. You would need an engineering expertise. There are firms that do specialize in this, that test. It is the wireless. If their facilities are overly emitting, if they're if they're not calibrated, they will not be functioning properly. So the proper functioning of their network depends on the proper calibration. There are, if you look at the spectrum of what's available and what's flying around, the mobile is a tiny, tiny piece of it. So there's FM, there's AM, there's Wi-Fi, there's traffic signals, there's utility signals. So there are literally 1,000 other things that are also in and out of the spectrum too. So we set it up so that testing does happen. We do work with providers that work with municipalities exclusively that do operate tests and that can interpret tests. But it is infrequent that we deploy resources like that.
I believe Mr. Campanelli said you could probably get some company to do a test for $400 in that range, but I don't know what that would be.
I don't know if you can park your car in Long Island for $400.
The thing is, we want constant testing, right? So is there something that measures it constantly that one can go onto their computer and, on an app or something and look to see what the levels are?
I am not familiar with the type of tooling or technology that you would need to do that. I understand at a basic level just from the regulations that what Mr. Campanelli says is true in terms of the classification of regular use and occupational use, but the standards themselves are set not by the amount that's coming out of the antenna, but by the amount that is reaching the people that are around the antenna. So occupational, and it's over a duration of time. So occupational use contemplates people that would need to be either servicing a tower or in an occupational setting where they would be exposed to these types of radio frequencies. And it's not just 5G, it's of all types of radio, MRIs, other types of machines. So this applies to different various categories. So in order to test it, you would need to be on location or deploy a way that you could be on location and measure it in a way that you're measuring the absorption into a human body.
Well, my interpretation, talking to residents, is suppose somebody claims to the township that they are being made ill by this antenna that's outside of their home. That's when you might want to test it. Just to follow up and, make sure it's within the FCC guidelines. And that way, you've done all you can to, hear what the resident is saying and respond to the resident.
So as a practical matter, would it be possible to articulate that kind of standard where we retain the right to test ourselves, in addition to asking the provider to test when we want them to, so that we have independent verification of what the measurements are? And concomitant to that, can you provide us with an engineering firm or whatever kind of firm it is that does this kind of testing to educate us about how that works and educate our municipal engineers about how that works, or our zoning officers about how that works, so we can see how involved we can get with it, or whether we have to retain some kind of expertise to do that testing?
Yeah, certainly. I could refer you to the municipal wireless mapping firm that we work with, and they could explain more about how that works. We draft this in such a way that the municipality retains oversight over the wireless operator and these types of facilities. We would want to make sure compliance is... I'm trying to think, without providing legal advice as to what happens if a resident makes a complaint about RF emissions and what the actual process would be and whether a municipality wants to get in between that dispute, because all of these operators provide direct resources and ways that if there's an issue, those things could be resolved. And in a way, it's also, we can set up here in the insurance that the wireless operators also indemnify the municipalities from any type of issue. But for the municipality's strongest protection, the FCC standards are the paramount standards. From a legal liability point, you would not want the municipalities meddling. I mean, just because, one, federal law prohibits them from setting the emission standards, but two, they would not want to be the ones to set the emission standards because then legal liability would accrue to them in a way.
Well,
So this is an ongoing issue. There are open lawsuits with the FCC to get the FCC to update its regulations. So that is an ongoing and active thing, and if anybody's interested in that, that's something that you could look into.
I might look into that, but I don't think we're looking at changing the levels
No,
or
we don't
anything
wanna-
like that.
We'll accept whatever the standards are.
Yeah.
We're concerned about if they're too close to somebody who is, their home in right-of-way area, and they have a medical reaction to being exposed to this radiation. We want to at least be in a position to know about it. We don't want to be in a position of being the only protector of our residents. I think that's sort of a mistake. I think they should retain the right to have their own lawyers.
What is the saying, trust but verify?
Correct.
So I might trust these companies to do their own testing, but I need to be able to have the power to verify it.
Okay, could I just point out, you're opening up to me a huge can of worms here. So everybody in their individual residence who gets whatever malady is going to call in and demand a test? I mean, I think the idea, if I'm correct, is that there's standards, there's testing going on. Presumably, if the radiation or whatever it is out of frequency or whatever, people would be alerted. But you really want to get in a situation where anybody can demand a test? I mean,
I'm not giving people the power to demand a test.
all right.
I'm just saying what happens when a resident makes a complaint. We didn't tell them you have the right to make a complaint. But if a resident has a complaint about a crosswalk, for example,
Right.
we do a study. Is this really a valid complaint? We have the police out there, and we spend resources to validate the complaint. So we need something similar for this. If a resident makes a complaint and maybe has a doctor's proof, that would be enough to at least go to the company and say, you need to test this and give us a report. But like I said, trust but verify. We need to be able to have the power to go over their head. Maybe we'll never have to do that. Mm-hmm. We can tell them, this resident has a problem. Can you go out there and test it? Because that's part of the ordinance, that they do regular testing. And if they come back and say everything looks copacetic, well, it's up to the township. Do we trust them or not, basically? But if you don't trust them, you have the ability to do your own tests and counteract that. Now, I don't know what happens if, there's two differences of testing. That's...
There are legal issues that are bigger than this ordinance involved in that.
But the ordinance is not requiring any township to do the testing. It's just telling the companies that we have the ability, written in the ordinance, that we can if so needed. That's basically all.
Right. I mean, I think we have to be careful and correct, though, that some citizen doesn't dig into the ordinance and go, aha, you guys put in there that I'm entitled to testing, you didn't do it, I'm sick, etc.
Yeah, we don't want to become liable for
Right.
something that they accuse us of being negligent in doing.
Right.
Again, the ordinance shouldn't say, we are going to do a test of every tower. That's not what I'm asking for.
Yeah, and we don't want to articulate too much, other than we just want to have the ability to do the test.
If
on our
necessary,
own. Yeah, if
that's all.
necessary. It would probably be a rare event when we.
Yeah, that's what I'm thinking.
Yeah, so feature that we would add to a draft, one of our draft ordinances, is to require that the operator certify compliance with all of the FCC and any other applicable regulations. And they have to do that at the application. They have to do that every 2 years, and then also on the request of the municipality, or in the event of an emergency.
Yeah, and we would also have the ability to get our own testing done if we felt the need to do it, but.
Yes. Yes, at any time. And so not to contemplate the discussion here, but these 5G facilities are ones that are sitting in the public right of way. These are stronger but similar to other Wi-Fi that people keep in their homes and businesses that are located pretty much all over the place. And now other providers like Verizon are offering people with landline connection the ability to have a 5G receiver for inside their house, to upgrade to 5G speeds inside their house.
Ooh.
And so this
I have a landline. Now I have a
this is
useful.
exciting areas of telecommunications law because these are open-ended questions and it's cutting
I don't have
edge.
to get a
But
new
for a lot
phone.
of municipalities, it's just headache on headache because, I mean, presumably you can't really regulate a private use of Wi-Fi, nor could you regulate somebody's use of a 5G style Wi-Fi in their own home.
I'm just curious, so if a whole neighborhood had landlines, then they wouldn't need the tower? Like, is it, if the technology's advanced one more level where you wouldn't need a tower in that case?
So some of them, they have one technology that runs if you have like a fiber optic connection to your house, then you can light up the rest of the house with a 5G modem, a 5G Wi-Fi modem, or there's another type if you have a line of sight to a small cell facility in the public right of way, then you can extend that coverage into your house.
It's on the water tower.
So
About
if I heard you
50 feet
correctly,
from my house.
most houses have a landline which is a fiber optic line, if I understand that correctly.
Not most houses. I mean, most houses are connected, but they're not. I wouldn't say they have fiber optics. It depends where you're located and what you have. But for these wireless facilities, a wireless network, 80% of a wireless network is wired. So in order to connect it, they have to connect into a wired facility.
So the question I have is that the average home that has a cable, whatever the cable is made of, that brings the internet line into their house, when they go to their service provider and buy the latest, greatest generation of high-speed connectivity, are you saying that they're buying an internal 5G connection?
Some of them, not everybody, but some. It is now an offering that's on the market. So if you're a Verizon Fios customer in an area where this is available, you can get a 5G Wi-Fi receiver for your in-home or in-business use.
So in our area, Comcast is the main provider, and they offer a product which is a high-speed connection. They don't use the words 5G, but that is probably 5G.
Well, do they have are you talking a high-speed cable connection, a broadband, or a high-speed cellular?
Wi-Fi.
Yeah, so Comcast is still operating on a cable-type network. So they're using Wi-Fi, which is a less powerful version of what 5G is. It's the same concept. It's like your portable handset inside your home is a smaller version of a massive radio tower that broadcasts AM radio for 100 miles.
So my question is that the 5G tower that people are concerned about the health issues, it sounds like people are actually bringing it into their house and not knowing they're doing it.
The people that are bringing it in their house, they know it's labeled as 5G, but the point is that this is existing in the public right of way, but it's also existing on private property. And so this is, the technology is expanding and changing and adjusting, and it's not just about 5G in the right of way, it's also your neighbor could have a 5G Wi-Fi box in their house.
Yeah, that's in essence what I'm asking, is that we're trying to craft an ordinance that's 100% perfect to protect everybody on 5G when this very same people are trying to vote on it and protect the community are probably bringing 5G into our own houses.
If it's Comcast, so everything is tough because Comcast, the cable company, wants to be a cellular company, and Verizon, the cellular company, wants to have a cable lineup through Fios. So everything is tough. So Comcast yet is not on 5G yet. If you're Comcast, they're not broadcasting anything in 5G. They do not have the spectrum permits in this area to run those operations. Any Comcast mobile, they're operating on somebody else's cellular network right now.
Like I have files
But
at my house, so.
Yeah, so it's clear under Pennsylvania zoning law, you can write a zoning code that would prevent your neighbor from operating a toxic chemical dump next to your property in a residential zone. It is not clear, there's not any authority that you could prevent your neighbor from using Wi-Fi, their Comcast Wi-Fi modem.
Interesting.
Can I just go back a second to what Tim said about opening the can of worms? If people start to say, well, now I'm getting sick and I want to be tested, what is the indemnification for the township if you have a large number of, somebody gets tested, they find out the radiation's off, then their neighbor wants to get tested, and then this neighborhood wants to get tested? Is there any way that we can indemnify the township where the residents have to pay for this themselves instead of having the township pay for all of it?
The township doesn't have to pay for anything. The township would go to the company, and give the report from residents or the residents.
If you trust that report from the
Well,
company.
no, they have to do the testing then. That's what our ordinance should say. First of all, they must test. And like you said, every 2 years or whatever it is, 6 months, I don't know. But we don't go in, the township shouldn't have to go in and test all the time.
That's what I'm saying. Shouldn't the
Yeah,
township
just
have to
because
go
a
in?
resident comes and says that they are getting sick from this tower that just went up the day before, that may raise suspicions, but you would tell them, well, they have the right, I assume, to go and make a complaint to the carrier, the company, first, okay?
Mm-hmm.
And the company would do that and issue a report, and the township should have a right to see that report. And if they don't trust the report, they should have the right to verify what the company is saying. That's all.
Well, who's gonna
They,
pay
the
for it?
citizen or the township?
Excuse me?
They, meaning the citizen or the township? If they don't
The
trust.
township should have the right to verify if it so desires. It's not saying you have to do it.
Certainly, any individual resident has the ability to retain the engineer necessary to do the testing on the.
That's right.
Should we put that in the ordinance?
Let's find out if we should. I'm not sure we should or not. The more you put in, the more it's going to attract attention. So I am somewhat concerned about making it the center of attention or attraction for the ordinance. I don't think that we want to be in the business of monitoring every 5G outlet in our communities, but we just want to have the ability to test if it becomes necessary, even if it becomes a public problem.
I mean, I like that language that says we reserve the right.
Yeah.
But the question is do we even need to say that? Don't we already have that right?
That's a good question. Joel, did you hear the question?
I'm not, yeah, can you restate the question, please?
So the question is that we're talking about putting the language into the ordinance that says the township reserves the right to test, in addition to the obligations that the carrier has. The question is, do we need the language? Don't we already have that right?
I think that the municipality, if the facilities are in the public rights of way, the municipality already has the right to do a test at any time because they're in the public right of way. But that language can also be added to make it explicit. In addition, we typically add language that, again, requires automatic annual certification, biannual certification of compliance with the FCC standards, and then at any point the municipality, upon a reasonable request, can get a test performed or have the carrier certify the compliance. We've never drafted an ordinance that would allow residents to use the ordinance to make a functional request for testing.
Right. We need some language in there, not just to do it, but to warn the carrier that we are serious about this, basically, and
Yeah.
might
And you
do
need
something.
language to enforce it too. It's not just about the testing, if you get back a test that has a negative response or an improper test response certification, or they fail to respond to the demand for certification, then what happens next?
Yeah, so we'd be interested in seeing how you would word all this. It'd be,
We would deem any operator that's operating above the levels that are set by the FCC to be an emergency operation. If they don't respond and they're not compliant, then they're in violation. They're making emergency operations in violation of the permit and the health and public safety, and then the permit would be revoked.
great, that sounds good.
That sounds like it's safe language to use, and I assume you use that across the board for all your ordinances.
That's it? No more questions?
Just a pro, you mentioned a lawsuit with fees. Are the carriers trying to whack our citizens to pay for all this?
Yes. Some of them in some places. So for these new, they're under the way that this, the draft regulation that you have here, and this is similar to the way that we draft our regulation, all wireless facilities are classified into 3 categories. The first is the tower-based, the traditional tower or monopole. The second is non-tower, which are on top of other buildings or water towers. These are always on private property. These are never in the public right-of-way. So on private property, they're lucrative for the landowner because there's a rental fee that the landowner can charge, an annual or monthly fee. For those 2 types of facilities, the municipality can only charge an upfront application fee, permitting fee. The third type is the new category, the small cell, and these are the so-called 5G facilities. And because these ones will 99% of the time sit in the public right-of-way, in addition to an upfront application fee, a municipality can charge a renewal fee, an annual renewal fee. And under the federal law says you can charge a reasonable compensation, and the FCC, through its 2018 order, stipulated that reasonable compensation to avoid most litigation is an annual renewal fee of $270 per facility per year. But if, and this is reflected in the Pennsylvania Act 50, if a municipality has reasonable costs that are reasonably calculated, you can exceed the $270 per year. And so for the city of Pittsburgh, they set their reasonable cost to manage the right-of-way. These facilities was set at $850 a year. And AT&T has filed a federal lawsuit over 2 facilities that they're applying for. They believe that $850 is too expensive. It's not a reasonable reflection of those reasonable fees, and so they would prefer to pay $270 per year.
Of course.
All right.
What about
1 year into the litigation, and we are now
CKS?
just getting to the initial scheduling of conferences and other things. So it is not a quick process. It's an unusual litigation. The city of Pittsburgh has permitted over 400 small wireless facilities. So every other carrier is there. Also, there's a third-party operator, Crown Castle, and AT&T actually rents from Crown Castle. So they are actually paying the city's fee. They're just paying the city's fee and Crown Castle's fee on top of it. So again, like I mentioned, this is a cutting-edge time for telecommunications law. Really exciting for us, but not always for everybody else.
Well, CKS, the town,
Engineers.
the engineers had a whole list of recommendations. I haven't looked at them in detail, but have you seen that,
That's from Michelle Fountain.
Michelle Fountain?
Yes.
Mostly that's.
Yes, these comments, these are reasonable comments. These are thoughtful comments, and these could be made. The changes could be made that are suggested in here.
Okay.
You would take them into consideration, and wherever you could, you would put that into the language of the ordinance.
Yes.
I have a question about something you mentioned earlier about whether this should be considered a conditional use or a special exception. What that really means is that there's something we want the planning commission or supervisors to handle and decide, or do we want it to end up in the zoning hearing board for a decision? In past, we have sort of put things in the hands of the zoning hearing board. It goes through the planning commission and through the supervisor, but ultimately it goes to the zoning hearing board for another level of review and consideration. What are your thoughts about that? What are most of the municipalities that you're working with planning to do? What's in most of your ordinances?
Yes. So the answer is the lawyerly answer of it depends. We have every single option. You can do them all the same for all of them. You can do each one different. Each municipality and the jointers can have their own process if they deem that that was most acceptable for them. From our perspective, we look at the guide rails under federal law. And so for us, the fees, to make sure that we don't discriminate against different carriers, and then also the shock blocks. So for different facilities, the time period to respond is different, and we would say if you can hit these time period shock blocks, you can use whichever method that you would prefer to use, but don't, going beyond the shock clock creates a presumption that you have violated, and so we don't want to do that. It's possible for both parties, and we have done this before, to agree to pause the shock clock, but for the regular standard process, we are always conscious to make sure that a municipality renders the decision in the available time.
This ordinance is all about the small facilities that can go in a private way. We're not talking about the large towers.
Yeah.
So given that, that's what we're really focused on.
Yes, sure. I can say what they are for the towers and the non-towers, but for each of them, there's what's called an upfront check for completeness of an application. And so for the small facilities, the municipality has 10 days to do a completeness check just to make sure that all the requested materials are with the application. And then it depends for the small facility whether or not they're going to attach their antenna to an existing wireless support structure, or they want an antenna and a new support structure. So if they're going to do the first one, just attach their antenna. It's a 60-day shot clock. And if they want a new antenna and a new pole, it's a 90-day shot clock.
So if this were before the zoning hearing board, they would have to have specific knowledge about what Mr. Campanelli called procedural restraints. And I'm it's above my pay grade to understand all that, and I assume the zoning hearing board would not understand it either. So,
well, the zoning hearing board generates procedural evidence routinely, and their job. I mean, that's what they do. You create a record. Under the Pennsylvania law, the small wireless facilities are an administrative review only. So these are facilities that cannot be conditional use or special exception. They have to be an administrative determination.
I get it.
Now, in that, there's a design aspect that somebody can review for compliance with the design guidelines, and that's often tasked either to a municipal manager or it can be any other any entity.
Like an engineer.
It can be an engineer, because the design standards. So the design standards under the FCC order have to be reasonable, and they have to be published in advance. So the facilities that you get, they could be from the same provider, but different facilities in different communities will look vastly different based on the level of engagement of the local municipality and what their regulatory authority and interest is to make sure that the design complies with the look and the feel and character of everything around it. And so everybody's seen those towers that are obviously fake-looking trees, and there are other towers that you drive by and don't notice at all.
Well, while you're on that subject, we looked at pictures, but can you just clarify? I think we've got a pretty good understanding. You've got one neighborhood that's got telephone. So our understanding is that you could put the 5G antenna on those. If you have another neighborhood where everything is underground, there's no poles, you will absolutely need, I know, towers or support structure for the new 5Gs. That's correct, right?
Yeah, so that's sort of a two-part question. If you allow 5G facilities in a place where everything is underground, then you would need something for them to attach it to.
And how many, is it a certain amount of towers per feet? I mean, you need more than one, right, I assume?
They often are installing more than one, but we haven't seen them moving densely into residential neighborhoods. We have seen a lot of expansion of the traditional towers, the capacity of the traditional towers. The marketing of the 5G got way ahead of the technology and their rollout of 5G. And then, quite frankly, the change in commute and work patterns of coronavirus threw everything off the map for them. So we have seen 5G roll out in concentrated areas. But again, to really work, that 5G network has to follow a hardwired fiber network, the main lines of those. So we are seeing a lot of expansion in the traditional areas.
Yeah, so I mean, like, I don't know if you can pin this down. I mean, my neighborhood has like roughly 50 houses. Let's say everything's underground. Would we need one of these new towers, 5, or is it really hard to say?
It's hard to say, and it's predicated on a lot of factors and whether or not there's a lot of like the load on your street and it's a network determination of where they're going to put this, and they're not blanketing everywhere in 5G. It's a concentrated maneuver for them.
Okay, thanks.
So if we were kind of following up on the neighborhoods where everything is underground, would it be possible to not allow towers or 5G in those neighborhoods? Can we get away with that?
Yeah, so this answer is also, it depends. So
It sounds like a lawyer.
From our perspective, one of the guide rails of the federal law is that you cannot discriminate against entities. You can't treat carriers differently than you would treat other utilities. So in a neighborhood where there are public utilities above ground, you can't relegate the carrier below ground. In a neighborhood where all of the utilities and everything else is underground, you do not violate that anti-discriminatory portion by requiring also for the wireless carriers to be underground. From our perspective, we try to flex the municipal regulatory authority as much as possible. So with the consultation of our clients, we do typically require that 5G facilities be underground in underground neighborhoods. Now that's a technological impossibility because an underground 5G facility, no wireless facility can work underground. So in order to make that happen, we have to look at the ancillary areas of where to provide coverage because we can't violate the other tenet of prohibiting or effectively prohibiting wireless service. But in an area where we put the 5G underground, if we can provide coverage from a tower or a non-tower facility, then we have not prohibited wireless services.
All right.
So does that go into the zoning ordinance or into the subdivision ordinance? Okay, because I think our current subdivision ordinance says that all utilities would be underground.
Yeah, so we would say in any underground zone or subportion thereof or any commonly developed property that requires underground.
That's good.
Yeah.
Okay.
Now, we couldn't put a blanket prohibition on 5G throughout the entirety of a municipality, but in areas where everything is underground, from our interpretation of federal and state law, we are prepared to stand behind authorizing the undergrounding of facilities where we can provide wireless coverage through secondary planning.
So underground and private streets in neighborhoods would be a fight against that.
Well, the only thing is that they do have an option if they put it inside their house. Via
Well,
the
that's
fiber
gonna-
optics, huh?
that's
So
gonna-
you're
that's
not
the-
totally
That's the
restricting,
biggest thing that I've heard tonight. Is that
Yeah,
all
that's
of
what
this
I
effort
heard.
is going to be
because you're not
Yeah.
really restricting them.
But in actuality, I don't care if you have it inside your house. I don't want to see, if I don't have electric poles, if I have everything underground in my neighborhood, I don't want to see a pole there. I don't care that you have one in your
Yeah,
house.
where I was driving at is that the carrier couldn't say, we can't give you the service, because the service could be put in their house with the 5G. That's
So
where I was
so it
going.
solves the appearance issue. It doesn't necessarily provide, it doesn't necessarily address this potential health issue.
Well, that's an individual if they put it in their house.
But assuming if it's in somebody's house, the person in the house next door wouldn't be exposed. Hopefully, the walls and such in the distance.
Yeah, is there anybody arguing that a personal router could emit enough of the microwaves to affect somebody next door? Because I gotta talk to my neighbors if that's the case.
I haven't heard
Because I have
anything
one.
about that. But, and the question also is, what's the cost variable here? I mean, what's the cost of that, the router?
But Ben's asking the right question, right? So if it does admit something that is of a health concern beyond the walls of your existing home, it's something we should be aware of.
Yes.
I don't know what
I
you
had
do
a
with it.
question, I don't know if we were
Well,
finished with that particular issue.
could Joel, do you happen to have the answer to that?
Sorry, can you say the question again for me?
So, this is not something I've ever thought about before tonight. I have a wireless 5G router in my home. I have no concerns about what it may be emitting. What I'm wondering is if there's any case to be made that what it is emitting could extend beyond the walls of my house and affect a neighbor. I'm imagining that when we've been having this conversation, it's mainly been about towers that are emitting, a stronger waves that could affect people at the base of the tower or near the tower, not the individual routers. So the question is that true?
I don't know about the health effects, whether or not a 5G router has health effects and what it extends beyond. I know that those types of, you flip it upside down, you'll see an FCC sticker on there, and that they have to comply with what the FCC regulations are. I don't know that there is any regulatory authority to regulate a wireless carrier in a public right-of-way and even on private property. I don't know if there's regulatory authority to regulate somebody's home modem.
Has that come up?
Separately, if there was a wide case issue of these types of devices that were emitting anything beyond what the levels are, I can assure you that there are many lawyers who practice different area of law that I practice that would immediately be trying to discover and uncover that information and act on it. But I understand, from our perspective, we want to do everything that we can to protect the health of residents and of businesses and of people that are in and out of these municipalities. And so we look to the regulations and the law and try to use the strongest languages and protections and enforcement that we can to enforce what the regulations are being set at the federal level.
Okay.
Dennis, did you have a question?
Yes, I did. It was, hopefully this is a quick answer. In Mr. Campanelli's review, and John captured it in his, the notice requirements. Is that something that we can add to the ordinance, and would that strengthen the ordinance in any way? I don't know if you recollect what he was saying is that a lot of the notices that they send out resemble marketing.
Yes, you can include a notice requirement, and you can require somebody to do it by certified law, and you could probably require a certain wording to be on the front of it and a certain size font. We do typically, the way we draft them is to require that notice requirement. We require proof of delivery. There's a UPS forms that can be filled out and then signed and then provide proof of delivery. And then also we require publication in local newspapers too. And from our experience, these wireless companies they're not gearing up for fights. They do not want to get into fights. They don't want to pick fights with municipalities. They don't want to get in between boards and commissions. They are in the business of getting these towers certified and set up. And they're not wildcat developers just setting up towers willy-nilly. You have to be licensed by the FCC in order to even submit an application for one of these towers under the ordinances that we draft.
No country for old men. No.
Joel, when you were talking about being able to kind of define the notice requirement, I mean, we have a general notice requirement for within the zoning ordinance for the zoning hearing board and how that's handled. Would we have to do that same notice requirement for all zoning hearing board hearings, or could we have it?
I would not. I would not want to make the notice requirement for wireless carriers overly onerous in ways that aren't for other portions of the zoning code. For other things, I think you'd want it to track it similar. But if you needed to tune up notice requirements for other portions like publication in the newspaper, that might be something that you'd want to do if an applicant complained about it. But again, for them, they like to see these regulations in that they understand that a municipality now knows what's going on. They like to see shot clocks and fee schedules and design guidelines because then they have something tangible to work with.
So guys, we need to be careful that if we're going to have, think about different notice requirements, that it could have a bigger input on the residents, because most of them are going to the zoning hearing board for any number of different things, and the number of applications. When's the last time we had a cell tower application? It's been a while. So.
Well, I was under the impression that the small cells also require notification if you're putting a small cell
like in the right
antenna. Yeah.
Mm-hmm.
So you also need to notify.
You require notification for any.
And I think Mr. Campanelli was talking about that, making sure it really looks like a notification, not like some marketing material.
Yeah.
In terms
but again,
of
there would be no open public hearing for a small cell facility that's on it.
It's just a letter.
Determination.
It's administrative. That means it has to be done by our manager or zoning officer or something like that.
Yeah.
Who sends out the letters? Who's
The applicant.
the applicant?
Yeah. And they have to prove to us that.
Yeah. And I just want to make clear too here that the townships considering this ordinance aren't considering whether or not to authorize 5G in these municipalities. 5G is already authorized under state and federal law. So what the municipalities are electing to do is to exercise their maximum right under federal law and state law to regulate these facilities, to determine what application processes they want, what information they want, what method of approval they want, the types of fees that they want within all these guidelines. So by taking action, it's not something that you're and allowing people to rush in. These are regulations that already exist, and by codifying these new standards, you're implementing your right to regulate them.
Well, I would just say we want all the rights we can get. And I know from experience that a lot of people don't read these letters, don't open them. And so anything that can be put in there that might encourage people to open them,
Yes.
I would approve of, I guess.
Yes. I think it's fine. We can require them to send certified letters, and we could require certain words to be printed on and bold font and to not be deceptive. I think that's certainly fine. I don't think we could require singing telegrams, but I don't think that's been proposed.
Can you get a radiation sign on it?
Skull and crossbones?
Yeah.
Let's not get too silly. More questions, folks, or we want to make a recommendation as far as something we wanted to do?
Just go ahead and do what you
Think about
do,
it, discuss it
and
more. It's been on our plate for quite some time, but I'm not pushing people to do things.
So it sounds like there's some additional changes that are needed in our zoning ordinance.
Correct.
So is the direction that we want to go is to have Joel and his colleagues work on it? To work, take a look, take our ordinance and redline it to add the additional items that need to be included?
I would make that motion.
Do we have a second? Tom? Okay, we have any discussion?
Can you remind us of the funding? We came up with a budget, I believe.
Well, it's funding is fungible with news.
$300 an hour for
Yeah,
federal services.
it's unfortunate.
Well, I think that's a reasonable question, though. I mean, is this, you know,
So what-
within a certain budget limitation?
Yeah, so Joel, what do you think it's gonna take hour-wise for you to clean up our ordinance?
We typically prefer to draft them from scratch or working from the existing ordinance instead of cleaning up what somebody else has drafted. So it's hard to estimate what it might take to go through word by word and redline somebody else's and change the structure and move it all around. For ordinances that we draft, it's typically about 15 to 20 hours, and that includes the drafting of the ordinance, and then also a round of first edits and conversations with a board of this nature. And anything beyond that is just hourly.
So you're saying it's more efficient for you and for probably less expensive for us if you start from scratch rather than trying to edit what exists?
I'm making all lawyers look bad, but I think it is cheaper for us to start from scratch than it would be if we tried to edit the existing one.
Sounds reasonable.
How much to explain that to the planning commissions?
That's why you're here.
Yeah. No, I can. I mean, I have worked with things that are a lot messier than this, so if it's the preference of the commission to say we have invested a lot in this language, we can work with it.
Well, I mean, just so that you understand and while the output may not be perfect, the fact is it's got to fit into the zoning ordinance. We have language in there currently from our old wireless communications requirements. They have to get stripped and in some cases maintained because we allow towers on certain properties, and I think we want to continue to allow that.
Mhm.
So, I mean, there's...
And we haven't sent him that ordinance.
Yeah, I
Should
mean, I
send
can
them
see
that.
that looking at the existing one. I can see where you've authorized towers on parcels and stuff. So for us, it's a collaborative process in terms of looking at what it has, and then we will tell you here in these zones, you can elect this type of process. Here's the different portions, the areas of the zoning map that you would want to look at, and we can tinker with. So I will tell you, here's where you can provide input, and my job is really to just provide the framework and to tell you, my advice of what I think is compliant with federal law and not compliant with the federal law.